Good morning, everyone. Thanks, everyone, for being with me this morning. My name is Jon Hyman. I'm a partner at Meyers, Friedberg Lewis. And this morning we are going to be talking to you. I'm going to be talking to you since there's no one else in the room here with me. I'm going to be talking to you about the right and I guess the converse, the wrong way to go about hiring employees, the legal way to go about hiring your employees. And hiring is always a complete and total crapshoot. You don't really know what you're going to get till you get it. There's some things you can do to feel comfortable with your decision, but there's really nothing you can do until you really get into the situation to make sure that you are getting the right person for the right position. I'll tell you a quick story, quick analogy, and then we'll get into the meat of what we're going to talk about for the next 30 minutes or so. So my family and I were on vacation about a month ago in Southern California, and we chose to use Airbnb for the first time for our lodging for the trip. And I knew we wanted to stay in Hollywood, kind of centrally located, so I went on the Airbnb website and started looking at kind of vacation homes and apartments in and around the Hollywood area to make our home base for our stay in LA, and found what I thought was a good one. The pictures looked really nice. It was a verified listing, meaning that Airbnb had gone in and actually taken the photos and verified that the unit in fact looked like what the pictures represented it looked like. The host, the property owner, was well reviewed on the Airbnb website, well over 4 stars. The property was well reviewed. We felt really good about our choice until the last night of our trip, when my 11-year-old daughter screamed in horror as she saw a 4-inch cockroach scamper across the wall of the unit, which hastened our retreat by about 12 hours. We left 12 hours early, found a hotel. And so the point of this is look good on paper, look good in photos. Didn't really know what we were getting, however, until we were in the unit and could actually kind of live in it for a couple of days to realize that what looked good on the surface was actually roach infested. And I'm not calling your employees roaches, but you've all probably hired a few over the years, and you haven't known that until you've got into it. So, let's talk about kind of how we go about hiring folks. And kind of the meat of any hiring process is the interview process. There's, lots of kind of how-tos on how to interview. What I want to focus on is not so much the how-tos, but the how-not-tos, and that is the things not to ask when you're interviewing folks. We know, for example, or we should know, hopefully we know, that our anti-discrimination laws protect us from hiring and firing decisions based on certain protected categories, such as race, sex, gender, disability, national origin, age, religion, genetic information, military status, and what have you. And so hopefully we know that when we are interviewing someone, we don't say to them things like how old are you, or tell me all about all the medical conditions you or your close family members suffer from. Those are clearly on their face illegal interview questions, but there are other things that you might ask in a job interview that might get you the same information that you still are prohibited from asking. So you can't say how old are you. You also, however, can't say what year did you graduate from high school or college, because a graduation year could reveal someone's um, age. You can't say, tell me all about your medical conditions. It would reveal a protected disability. You also can't say, tell me about your history of workers' compensation claims, because that would also reveal a history of medical issues potentially. What can you say, right? Because you want to know that someone is medically able to do the job. Um, you can't say, tell me all about your medical history. You can say, this is a job description, or these are the essential functions of the job. Can you perform all of these with or without a reasonable accommodation? And if the person says yes, conversation done. You have the information you need to have. They can do the job physically. Um, Case closed. We'll talk in a little bit about medical exams, pre-employment medical exams, and what you're allowed to do there as well, which layers another piece um, into this puzzle. Certain accommodations you have to make when you're interviewing folks for jobs. Title VII is and the ADA are by and large laws of prohibition. You can't do this. But in two particular categories, that being religion and disability, they are also laws that require you to do certain things, and that is make accommodations. So, for example, in the religious category, you have to provide accommodations for employees' religions, um, unless those accommodations cause you to suffer, you the employer, to suffer an undue hardship. What types of accommodations are we talking about? For example, if you are hiring a Muslim employee, female, and that employee wears a hijab, the religious head garb um, and robe. Title VII probably says that you have to allow them to wear that on the job. You can't not hire them because they wear a particular religious garb, or you can't not hire them because their religion requires them to take certain days off from work. You have to, and the same holds true for disabilities. You can't not hire someone because someone has a disability or needs an accommodation. You can't not hire someone because someone's disability prevents a roadblock for them even applying for or interviewing for the job, right? If someone is blind, you can't say, well, you can't see to fill out an application, we can't hire you, we won't even consider you. You have to make an accommodation for them to do that. And so Title VII, the ADA, require that you consider an employee's religion and disability, and consider whether there is a reasonable accommodation that will enable the person to perform the job. And more importantly, both laws say that you don't even know if there is an accommodation unless and until you engage in what's called the interactive process with an employee. So you have to have a discussion with the employee, or in this case, we're talking about hiring the applicant, to determine, is there an accommodation available that will enable the employee to perform the essential functions of their job, notwithstanding the employee's religion or disability. And you can't make that determination until you sit down and talk to the individual. So, for example, you have an employee that comes in wearing a religious garb, or has a religious hairdo or beard, and you look at this person and you make the determination that their appearance, because of their religion, will prevent them from wearing some protective gear that we require in our industry. Someone can't do their job without wearing this protective gear. It would be, an OSHA violation. It would be dangerous for the employee, whatever. We're not even going to consider this person. Strike three, you're out. You have to have a conversation with the individual to say, these are the requirements of the job. This is what we require. Can you do this? And if not, is there a way for you to do the job and meet your religious requirement, or the requirements of or the restrictions of your disability? And if you don't have the discussion, you've failed in your obligation to engage in the interactive process. and you have almost certainly violated the law before you've even, brought um, the employee in the door. Another unique aspect of our discrimination laws is that our discrimination laws don't just prohibit intentional discrimination, they also prohibit unintentional discrimination. They, through a theory called disparate impact, our discrimination laws prohibit employers from applying facially neutral policies that statistically impact one protected group more than another. It regulates how employers engage in pre-employment background searches. It's called the Fair Credit Reporting Act. It is a law of nuts and bolts. It is extraordinarily complicated. There are numerous hoops that the law requires employers to jump through, both before running a background search on an employee or prospective employee, and before and after taking an adverse action, that is not hiring or firing an individual because of information that shows up in a background search. The Fair Credit Reporting Act is unfortunately named because it has the word credit in its title, and so lots of people mistakenly believe that the Fair Credit Reporting Act only applies to credit searches. So, information relating to a consumer's credit information, how they handle their money, how they pay their bills, and the like. That's actually not true. The Fair Credit Reporting Act, despite the word credit in its title, applies to any information that one obtains from a third party that could potentially bear on one's character, reputation, and the like, which includes things like criminal background checks, reference checks, interviews, educational backgrounds, even personal interviews with people about someone's character, fitness, and what have you, all fall under the umbrella of coverage of the Fair Credit Reporting Act, and all require that you jump through myriad hoops before you get the information, and then before and after you take action based on the information. Because the statute is very technical, it also makes it violations painfully apparent, and it makes it very easy prey for plaintiffs' lawyers to file quick and tidy class action lawsuits, of which there have been hundreds filed in the last few years all over the country against employers who failed in one of their steps under the Fair Credit Reporting Act. So what does the Fair Credit Reporting Act require you to do? Number one, it requires that you, in a document separate and apart from any other document you give an employee, so you can't bury this in an employment application, but it has to be in a separate standalone document, that you notify an individual that you are going to be running some kind of background search on them and get their written consent. That's number one. From there, once you get the information, there's then a whole bunch of other things you have to do, including before you make an adverse action, take an adverse action against the individual. So let's say you have the notice, the person disclosure, the person signs off on there, gives their consent. You run a background check, and you find out that the individual has, either a bunch of undisclosed felonies. They lied on their application. They haven't disclosed a bunch of felonies that they've been convicted of, or some other disqualifying factor in employment. And you now don't want to hire that person. You cannot, under the Fair Credit Reporting Act, just not hire the person. You are going to be taking an adverse action based on information that was discovered in a background search covered by the Fair Credit Reporting Act. You have to give them what is called a pre-adverse action disclosure. Okay, so what does that mean? You need to notify them by giving them a copy of the report that this is information that you are considering using in the hiring process. You have to give them a document that's been written by the government that describes their rights under the Fair Credit Reporting Act. And then you have to wait. You have to wait a reasonable amount of time, which the statute says is typically 5 days, before you can then take an adverse action against the individual. And once you wait that statutorily prescribed 5-day or longer period, you then give them a second adverse action notice, or a second notice. This is called the adverse action notice, which then notifies them the adverse action, gives them the contact information of the consumer reporting agency from which you obtained the information. All this is done so that individuals can, the pre-adverse action is done so that the individual can learn that you're considering taking this action. You then have to wait a period of time to give the individual an opportunity to dispute inaccurate information, right? So let's say you run a background check on John Smith. It comes back with that John Smith has committed 15 felonies all over the country. One of three things has happened. Either John Smith did those things, number one. Number two, you obtained an inaccurate report. That is, the consumer reporting agency gave you information on the wrong John Smith. Or number three, someone stolen his identity and has posed as him and committed all these felonies. The idea of the pre-adverse action notice and the waiting period is to allow the individual an opportunity to address options 2 or 3, wrong report or identity theft. If it's them, if they did it, then nothing they say is going to convince you otherwise. Then they are who they are, and you're going to make your decision accordingly. But if it's not them, right? Jon Hyman applies for a job, and it comes back as Jon Hyman, robbed a liquor store in South Carolina in 2003. I promise you, I did not. And so either they have the wrong Jon Hyman, or someone is engaged in identity theft and has an ID with my name on it, or whatever. So the point is, you have to wait to give that opportunity to dispute, and then you then have to give the individual the adverse action notice, letting them know that, yeah, this is, we've made this decision, we're not hiring you, and then you can, and this is the consumer reporting agency we got the information from, take it up with them. That is the nuts and bolts process of what you have to do. Technical statute, again, one violation at any step of the way is going to likely subject you to liability. And because these violations typically are systemic within organizations, we're not getting disclosures, or we're not getting consent, or we're not giving notices, or we're giving one notice instead of two. Really easy pickings for plaintiffs' lawyers who are making a killing filing these lawsuits all over the country. Last thing I want to talk about is what I call the Google background check, but this is what more and more employers are kind of falling back on, turning to as part of their background screening process. There is a wealth of information that is available online by individuals, about individuals. People have their Facebook profiles unlocked, and you can see, everything about them. People write blogs or tweet or post photos on Instagram, and or post comments on websites, or whatever. So, and you want to know, you likely want to know when you hire someone. There's lots of good information you can discover about somebody online. You can discover how they behave online. Do they post racist or sexist or degrading conduct? Have they ever trashed an old company online? Have they ever posted confidential information of a former employer? Do they appear to be a good cultural fit for our company? Do they exhibit poor judgment by posting photographs of them excessively drinking or using drugs or whatever? All kinds of good information you can find out about an individual by just typing their name into the search bar on Google or on Facebook or whatever. There's a way this can go horribly, horribly wrong for you, however, and open you up to liability under specifically the anti-discrimination laws. And I started with a personal example. I'm going to close with a personal example to kind of illustrate how this all could work badly for an employer. So I have 2 kids. My daughter Nora is 11. My son Donovan just turned 9. And Donovan was born with a genetic disorder called Noonan syndrome. If you Google Noonan syndrome, There's a wealth of information you can read about it, and it's a spectrum of like 250 things that can be wrong with you as a result of Noonan syndrome. In Donovan's case, he is short in stature, although he's on growth hormones that I'm told is growing at a very rapid pace, which is awesome for him. He has a heart defect, he has a bleeding disorder, he has celiac disease, and he has recently been diagnosed with ADHD, all of which is attributed to this mutation of his PTPN11 gene, which is more commonly known as Noonan syndrome. When he was 2, he ended up hospitalized at the clinic for 3 weeks because at the time we didn't know he had a bleeding disorder. And he had a fairly routine procedure done that ended up developing into a somewhere between a golf ball and baseball-sized hematoma in his intestine, which needed, because we didn't know he had this bleeding disorder, which needed to subside before he can then go home. So this was February 2011. He's in the hospital. We're coming up to Valentine's Day. I don't know what to, give my wife as a Valentine's Day present. I didn't think that she wanted the commemorative Cleveland Clinic t-shirt or sweatshirt so she could always remember the fine 3 weeks that we spent together with our son in the hospital. So what I decided to do, at that time I had been blogging for 2 or 3 years with my legal blog. I decided that I was going to set up a blog for her. At the time, she was a stay-at-home mom, so she could write about, use it as an outreach tool to reach out to other parents that were going through the same kind of stuff that we were going through with Donovan. And for a handful of years until she went back to work, she blogged fairly regularly, and writing about a lot of Donovan's medical issues and the like. So now fast forward a few years, our kids are now in school full time. She's ready to re-enter the workforce. And if you type her name into the search bar on Google, you will find her blog, and you will find out that, our son has a genetic disorder, and we have these medical conditions, and so if you're an employer and that bell is rung, this employee that you are considering hiring is dealing with these medical issues at home with their family and whatnot. That may, in your mind, disqualify that person from working for you, period. But certainly if you're presented with 2 employees or 2 applicants of relatively equal strength and qualifications, objectively speaking, you would say, I would rather hire the individual that I don't think is going to need excessive time off for medical issues, period. And I think most people, if they're being honest, would answer that way, which, by the way, is also 100% illegal because the Americans with Disabilities Act protects against disability discrimination, and the Genetic Information Non-Discrimination Act protects against discrimination on the basis of genetic information, and making that decision based on what you read in the blog post about someone's family's medical issues related to a genetic disorder would violate both those laws. So what do? Because you want to be able to engage in these searches. You want to know, are there racist posts, sexist posts of drug use, bad communication, trashing an old boss, disclosing confidential information, but you don't want the protected medical information. So what I have recommended for years that employers do, and I'm going to reiterate my advice again, because I know there's still employers out there that are hearing this for the first time or are still doing this incorrectly, you need to make your decision in a vacuum. And how do you do that? You need to train someone in your organization that is external from the hiring process to run these searches, these online searches for you, and then give to the people making the hiring decisions filtered search information. So they will give you the good information that you want to base your decision on, but filter out from that report the bad information, the protected equal employment opportunity information, the information that's going to disclose race, sex, age, disability, religion, national origin, genetic information, military status, whatever protected category there is under the law will be removed from this report. And the individual making the hiring decision will receive a you will receive a sanitized report that will give you the good information that you want to make the hiring decision based on, but leave out the protected EEO information that you never, ever, ever, ever want to consider. And so with that, I thank you all for your time this morning. It was a 1.5 times, due to my technical issue, run through everything you want to know about hiring employees in 30 minutes or less. I thank you all for your patience as we work through the audio issues. This is my contact information. I am very easy to find. You can certainly go to meyersroman.com and find me there. My email address. I write about these issues, or these and other issues related to employment law 5 days a week at the Ohio Employers Law blog, www.ohioemployerlawblog.com. You can find me in Workforce Magazine, the nation's largest HR publication, monthly publication, where I write a monthly column and blog for them also. I'm on Twitter, I'm on LinkedIn, I'm on Facebook. You can just type in Jon Hyman Employment Lawyer or Jon Hyman Meyers Roman, and you'll get all this information as well. I don't hide. I'm easy to find, and you will get updates, probably more updates than you want from me once you find me online about all this information on a daily basis. And we had one question that came in through the webinar portal, which is, what are considered reasonable accommodations for religious practice? Your cartoon at the bottom of page 1, for example. So here we are. Here we have, I only request, you have someone that's looking to work for a lemonade stand, but says, by the way, I need prayer breaks and then the gender segregated adorned prayer room that you'll provide for me. All very kind of tongue in cheek, but not really, because employees of certain faiths do need prayer breaks. There are employees that may not be able to work the Sabbath, for example, or may need to take breaks during the day to face Mecca and pray, or may need to wear certain religious garb. Prayer breaks is kind of low-hanging fruit. Give them. I would suggest to employees that they do as best they can to fit it into your normal break schedule, whatever that may be. But if they need to take an extra break during the day to pray unpaid, and it doesn't overly interfere with your production, then I suggest that you will more often than not save yourself the aggravation of a lawsuit if you deny these accommodations. The more onerous the accommodations are, the more difficult these requests become. I'll tell you 2 stories, and then I'm going to close it out for the day. One personal, as I love telling personal stories, and one from an actual lawsuit. So when I was in high school, I worked at a clothing warehouse. I had been there for like 3 or 4 days, and one of the guys who worked there came up to me and he goes, "Hey, has Harlan talked to you yet?" Harlan Jester was his name. Also a true story, because Harlan was a bit touched. He named his son Court. So he, honest to God, had a son named Court Jester. But this guy came up to me and said, "Has Harlan talked to you yet?" And I said, "No, I don't know what you're talking about." He goes, "Oh, well, you will when Harlan does." And sure enough, that afternoon, Harlan came up to me with a stack of pamphlets in his hand and said, "Let me tell you about the apocalypse that's coming." Harlan believed, for example, that the Freemasons controlled the world from a secret office on the 35th floor of Rockefeller Center. Harlan believed that Lee Iacocca saved Chrysler by making a pact with the devil, and Harlan believed that the rapture was coming and had all the literature to back up his beliefs. I smiled and nodded politely because I didn't really want to upset Harlan, and went about my business. A couple weeks later, and we all had these old work desks that we worked at. A couple weeks later, a drawing, and I mean picture perfect drawing of Lee Iacocca, caricature, appeared on Harlan's desk with a little bubble coming out of his mouth that said, "Harlan, I'm watching you." And Harlan went nuts because he really believed that Lee Iacocca had made this pact with the devil, and then really believed that because this drawing It never occurred to him that somebody was messing with him. This drawing appeared on his desk. Harlan went running into the HR office and said, "I need a new desk. I need a new desk. My desk is possessed by the devil." Um, and um, and HR could have easily said, "Harlan, you're nuts. Go back to work." What HR did instead was got Harlan a new desk. They put that desk in storage, pulled another one out. Problem solved. Um, that's that's example number one. Example number two, you have a recent lawsuit where an employee refused to, the employer required the employees to scan their hands. That was their time clock, that a biometric hand scanner was their time clock. An employee refused to use the hand scanner because he believed it was a tool of Satan. See a theme here. The employer said, "Those are our policies, those are our rules. If you don't like it, go work somewhere else." And instead of getting him an alternative to keeping his time, they fired him when he refused to use the hand scanner. He sued and cost the employer, hundreds of thousands of dollars to prove its case. So there's two ways to go about this. I think the being accommodating where possible is the much better solution for most employers in most cases, because it is going to be more often than not the much more cost effective solution. One more question that just came in, talking about the background checks. Just to clarify, in regards to background checks, you should not Google an applicant, but only use a third party to run them, i.e. you should not look at the Facebook account for further information. Using a third party is one option that will cost you money. The better option, I think, and this will depend, I think, on the size and sophistication of your HR folks, or the people that are doing your hiring for you, your office staff, is use someone. You can use someone internal to your company, but you want them to be external from the hiring process. So have someone in your company go ahead and look at the Facebook account or type the name into Google, but just make sure that that's not the person doing the hiring, making the hiring decision. And then whoever is running the searches for you, they'll print out a whole bunch of information to give to the person making the hiring decision, but they won't provide protected EEO information, race, sex, age, religion, disability, what have you. And again, this will depend on your comfort level with the sophistication of the people in your organization, and their ability to understand kind of what they're looking at and what they're not to give to the people making the hiring decisions. And it's going to take some training, and there's going to be a learning curve, but it's going to be much more efficient and cost effective in the long run if you can train people to internally to do this, as opposed to kind of undertaking the expense of having a third party do it. But there are lots of third parties out there that will do it for you. So with that, again, I thank you all this morning. It's been a pleasure being with you all. Sorry for the technical difficulties and the delay in the beginning. And we will see you all again next time. Thank you all very much.